Now, I'm sorry I was a bit long. The next speaker, Catherine Latimer, will deal with what was the rule in Hollington and Hewthorne. Catherine Latimer is also a member of the research facility, Canada's most sophisticated legal research operation. Catherine was at Queen's University, where she obtained her LLB in 1978, and before that she was at the University of Waterloo, and then after obtaining her law degree was on to the University of Cambridge in 1978 and 79, where she obtained a Master's of Philosophy in Criminology. She articled at Osler, Hoskin, and Harcourt, and was called to the bar in 1981, and joined me at the research facility in 1981, and has been a most excellent researcher indeed. Yes? Do you want to take it? Yeah.
Good morning. I realize that there are still a couple of speakers between now and your coffee break, so I'll try to move through my material as quickly as possible. It's a fairly discrete issue, so it shouldn't take that long. Okay. Perhaps inspired by the success with the Constitution, the drafters of the proposed Canada Evidence Act are also attempting to extricate from British origin the rule regarding the admissibility of prior judicial findings. At the moment, the governing principle in Canada is the rule of evidence propounded by a 1943 decision in Britain called Hollington and Hewthorne. The Supreme Court of Canada approved of that decision in 1956, and it has been the rule in Canada since then, although it has been abolished by legislative fiat in Britain itself in 1968 and in many of the other common law jurisdictions. However, when Bill S-33 is proclaimed in force, if it is proclaimed in force, the rule will no longer be the governing principle in Canada. Now, I assume it's incorrect to suspect that everybody remembers what Hollington and Hewthorne was about from their law school days, so I'll just briefly go through the case once again. In that case, the plaintiff was seeking damages from the defendant in connection with an automobile accident. An employee of the defendant was driving another vehicle involved in the collision. The driver of the defendant's vehicle had been convicted of dangerous driving, and the plaintiff was seeking to introduce into evidence the certificate of conviction in order for it to be evidence suggesting that he was negligent in the operation of his motor vehicle. However, the Court of Appeal held that the plaintiff was not able to introduce the defendant employee's conviction for dangerous driving. Lord Goddard, speaking for the court, suggested several reasons why this would not be wise. He suggested the admission of the conviction would be of marginal value in assessing negligence, and the opinion of the criminal court should be accorded no more weight than that of a private bystander. Furthermore, he suggested, based on the maxim of res inter alios acta alteri non debet, which according to the Black's Law Dictionary means things done between strangers ought not to injure those who are not parties to them, that it would be unfair for a finding between A and C against A to be binding on A in a proceedings between A and B. Now, I have some difficulty with that because the finding against A was a party to the initial proceedings, so it isn't something that was done to a stranger to those proceedings, which would be injuring him in a subsequent court proceedings, because he would have had ample opportunity to defend himself or represent his case in the initial proceedings. However, Lord Goddard is entitled to his opinion, of course. He also suggests that if evidence of convictions are admissible in subsequent proceedings, then evidence of acquittals should also be admissible. Essentially, the rule that was expounded in the case is that simply that although pleas of guilty may be admitted in subsequent proceedings as admissions, or confessions, findings of guilt are not admissible in subsequent court proceedings. In Britain, dissatisfaction with this rule was pronounced in relation to some anomalous results in slander and libel cases. For example, in the case of Goody versus Odom Press Limited, one of those convicted in the Great Train robbery brought an action against a newspaper that had referred to him as a Great Train robber for damages. Now, the onus lay on the defendant to establish the plaintiff's guilt, and because of the rule in Hollington and Hewthorne, he couldn't rely on the certificate of conviction, suggesting that he was guilty, in fact, of the robbery, and he was unable to establish his case on other grounds, so the Great Train robber was successful in his action for damages. So much for Britain's sense of fair play. However, it is likely it is not simply the indignation at the results of slander and libel hearings that led to Britain and other jurisdictions overriding the rule in Hollington and Hewthorne. It was possibly an interest in expediency and a desire to propagate the notion that justice should be seen to be done. There's a tendency to want to ascribe a certain amount of credibility to judicial systems. Now, if a criminal conviction or other judicial finding is reached in accordance with the principles of fundamental justice, then in the best of all possible worlds, that finding should in some ways reflect the truth. Now, if the truth is reflected in that judicial finding stemming from similar facts, why should there be a subsequent judicial hearing in order to establish the same truth? The only difficulty with that is if there is any question of the initial court's ability to make a fair assessment of what is true. Of course, there are some difficulties in terms of applying the first truth to what is being sought to be achieved in the second hearing, but I'll deal with that later. Before considering the implications of the proposed changes, I'd just like to map out what in fact those changes might be. They're contained in Section 74 to Section 79 of the bill, and the general rule is expressed in Section 74, and it's expressed as a prohibition against the admissibility of findings of other courts unless the finding is used for an enforcement proceedings or the finding is an exception, statutory exception set out in the Act to one of the statutory exceptions set out in the Act. And they are set out in Sections 77 and 78. Now, in order to determine whether or not a judicial finding is an exception, the definitions contained in Section 75 are in some ways useful. Conviction is defined in Section 75 as including convictions in respect of which a pardon might have been granted unless it's a free pardon. And this makes sense because only free pardons, although there is a wide variety of pardons available under the exercise of the royal prerogative of mercy and in the Criminal Records Act, it is only free pardons which negative the guilt. They're available if the court finds out that somebody else has in fact committed the offense, or there's some proof that the person who had been charged with it did not in fact commit the offense. Furthermore, contrary to the suggestion of Lord Goddard in Hollington, the drafters of the legislation do not seem to be of the view that the admissibility of the convictions would necessarily require the admissibility of acquittals. It's probably the disparity between the standards of proof in criminal and civil proceedings that may account for the reluctance to attribute probative value to acquittals. In fact, Lord Goddard, when he was introducing the bill which led to the evidentiary legislative changes in Britain in 1968, commented that, quote, "An acquittal has, as everyone realizes, no probative value at all, since it is perfectly consistent with the criminal courts having been of the opinion that the accused was probably guilty." A further point is that the admissibility of the conviction is no longer affected by whether it resulted from a finding of guilt or a plea of guilty. Court is also defined in Section 75. It's defined to include a court-martial under the National Defense Act, but in order to get a fair appraisal of what court is, for the purposes of these sections, it's important to look at the definition section in Section 2, which gives a very broad definition of court, ranging from the Supreme Court of Canada down to stipendiary magistrates and anything that's described as being a court for the purposes of being a court. So there's a very broad range of judicial bodies who can make a finding that could be admitted in a subsequent hearing. Furthermore, offense is also defined in Section 2 of the proposed legislation as meaning an offense under any enactment of Canada or of any province. Again, it's a very broad gambit that's being canvassed by that provision. Section 75 expands the definition of offense slightly to include offenses in respect of which court-martial is held pursuant to the National Defense Act. The task force was of the view that the federal government should not be shielded from the wrongdoing of its military personnel, and a defendant should not be given an evidentiary advantage merely because he is a member of the task force. I just have one comment to make with regard to the application of the exceptions in Section 77 and 78 before we get to what those exceptions are, and that is that the bill provides in Section 76 that it must be an ultimate determination of guilt. So they are not admissible if there's still a chance to appeal from those provisions. So the appeal period would have to elapse before they could be admitted. Other jurisdictions have not found it necessary for it to be a final determination of guilt and will admit it regardless of whether or not there's a appeal pending. It's particularly the United States in Rule 803, sub 22. Okay, the statutory exceptions to the prohibition against admissibility are set out in Section 77 and 78. And I have presented these in sort of a tabular form at page 321 of your materials, and you might want to turn to that in order to follow along. For the purposes of comparison, I have divided the material contained in the sections into three categories: the forum, the finding, and the weight that can be ascribed to the finding in a subsequent hearing. The most interesting one I find is Section 77.1, which is the broad inclusion of criminal convictions and civil findings. You'll note that the findings listed in the second column also include a discharge. This was necessary because a discharge, although a finding of guilt, is not necessarily a conviction, and therefore it might not, in the absence of an express inclusion, be admitted in a subsequent hearing. Furthermore, findings of adultery in what I've marked as B are also included as a possible finding that could be admitted in a subsequent hearing. This inclusion stems from arguments that were made that a spouse of a co-respondent in an earlier divorce proceeding should be able to use that finding of adultery to establish that adultery occurred for the purposes of her own divorce or his own divorce, whatever the case may be. The rule in Hollington and Hewthorne, of course, prevented findings of adultery from being used in this way, and arguably put the petitioner to undue expense and inconvenience in requiring proof de novo. However, it should be noted that Section 77.1 of the proposed Act does not restrict the use of these findings of adultery to subsequent petitions for divorce from the correspondent's spouse. So it has a much wider ramification of that. And in fact, a finding of adultery is in fact a finding of sexual intercourse. So as practitioners, you might want to be alerted to other civil ramifications for damages that could ensue from that. For example, in British Columbia, there could be a suit based on damages for loss of matrimonial consortium. If the woman became pregnant at any time, there could be damages or child support or findings of paternity, or I don't know, there could be damages for intentionally inflicting sexually transmitted diseases or whatever. But one should be careful because there are often a lot of gratuitous people who are willing to have their names used as correspondents, not that they did not have intercourse with the woman or the man who's seeking the divorce, but simply as a technical use of the word. And I think that you should probably look at that fairly skeptically if someone is suggesting that they are willing to be a co-respondent. Okay, furthermore, it might be noted that the Evidence Act in Britain, the comparable provision, also includes findings of paternity that could be admitted in subsequent hearings. There's no equivalent provision here. The reason being is that in many jurisdictions, certainly in Ontario, there can be finding of paternity against more than one person, especially for the purposes of support. Now, under the Children's Law Reform Act, particularly sections 4 and 5, there can be declarations of paternity which are supposed to establish parentage for all purposes, but the drafters of this bill have thought in their wisdom that it might not be fair to have a finding of paternity used against a person in a subsequent civil action when its effect may be limited to that particular initial hearing. Okay, the most interesting aspect of these exceptions is the weight that would be ascribed to the finding, the initial court finding, in a subsequent hearing. Bill 33 treats findings as evidence admitted for the purpose of proving that the offense of adultery, or the offense or adultery was committed by the person. It does not shift the burden of proof, nor is there any statutory limit placed on the admissibility based on the severity of the offense in question or on the level of court rendering the finding. In the United States, for example, the admissibility is restricted to convictions for offenses that were initially punishable by at least 1 year imprisonment. The commentary, the rule that specifies that is Section 8, is Rule 803, Sub 22, and the commentary accompanying the rule suggests that, quote, the practical considerations require exclusion of convictions of minor offenses, not because the administration of justice in its lower echelons must be inferior, but because the motivation to defend at this level is often minimal or non-existent. Hence, the rule includes only convictions of felony grade measured by federal standards. The South Australia Evidence Act excludes the admission of convictions from other than Supreme Courts unless it is thought to be in the interests of justice to make the inclusion. Okay. Now, I'll discuss a little further on a little bit about what ramifications of that sort of broad scope of what might be admitted, of what may be admitted might be. In slander and libel actions, which is covered in Section 77, subsection 2, both convictions and findings of adultery might be used in subsequent hearings, and they are conclusive proof of the commission. The purpose of the conviction being conclusive proof is to prevent a convicted person from having the issue of guilt tried over again in a libel or slander action. However, if you're representing someone on this basis, it should be noted that the conviction should not be a complete answer if the defendant's statements encompass facts beyond those leading to the conviction. Now, in order to discern what might be challengeable, we'll have to look at Section 79, which includes what is admitted in order to establish the conviction, because it seems to me there's sort of a narrow range of things that are admitted, so it's hard to know whether or not the defendant's statement is greater than those facts leading to the conviction. Now, in criminal proceedings, Section 78, the proposed act goes beyond merely abolishing the rule in Hollington and Hewthorne and permits not only criminal convictions in subsequent civil hearings, but criminal convictions in subsequent criminal hearings in 2 circumstances. These are fairly clearly set out, but I'll just say that the weight to be ascribed to these, possession of stolen property and the accessory after the fact, is a rebuttable proof that the property was stolen and rebuttable proof that the offense was committed. Okay, just a brief note about Section 79, which are the procedural elements. Section 79(1) requires that the identity of the person as the offender be proved before documentary evidence of the finding is admissible. The task force suggests 3 methods to establish the identity of the accused. The first was the testimony of an eyewitness who was present in the court when the prior conviction was recorded. The second was a comparison of fingerprints under Section 594 of the Criminal Code. Or 3, the similarity of the name and address of the person and that recorded in the document as prima facie evidence. The type of documentary evidence that is admissible to establish the conviction is set out at Section 79(1)(a) and (b). And you'll note that the range of documents available is much narrower than that accepted in other jurisdictions. Also should alert you to the notice requirements that can work against you and for you depending on what position you're taking. Section 79 specifically provides that the notice requirements in Section 139 of the bill are applicable. And therefore, there has to be 7 days notice of an intention to introduce the document. So if you're seeking to introduce the document, make sure that you give your notice, and it may be possible to challenge the admission of the document if the 7 days notice was not given. Now, I'd just like to point out a number of practical considerations that might flow should these provisions be incorporated or should the act be proclaimed in force. I've already noted the one that concerns me about the admissibility of findings of adultery and the sort of, in this day and age, the moral turpitude ascribed to adultery is not as great as it once was, and therefore there seems to be a tendency for people to admit to adultery, be more willing to admit to adultery. I'm not saying that they didn't commit it, I'm just saying that they're willing to admit it. And this could have severe civil consequences for them in damages or whatever. So you might want to advise them as to what the consequences might be should they be thinking about presenting themselves as a correspondent for the purposes of someone else's divorce. Furthermore, there may be some difficulties. I'd just like to emphasize the point I started to make earlier about the disparity between the truth being revealed in the initial judicial finding and the practical considerations which might have in some way infringed on the actual truth being revealed. For example, let's say that your client was charged with loitering. In fact, he was scalping tickets outside of Maple Leaf Gardens. I know this happens. They just charge them with loitering. And what usually happens is that the person does not want to have a criminal record, so they want to bargain the charge down to an offense under the Ontario Ticket Speculation Act, which is usually punishable by a nominal fine. Okay. Now, the question is whether or not you should plea bargain it down to an offense under the Ontario Ticket Speculation Act, which in fact it probably is. Now, should you bargain it down if you happen to know that Ticketron or Bass Ticket Outlets is standing outside of the courtroom with a writ under its arm to sue your client for damages that have ensued by him selling the tickets at below market cost or above market cost or whatever? Now that's, what is more confusing is, did you not get that? Okay. What happens is, let's say that your client is scalping tickets outside of Maple Leaf Gardens. The police come along, they charge him with loitering, okay? The client wants to plead guilty to an offense.
I understand that part, but I don't see the damages by ticket.
Oh, well, I am just sort of speculating as to what civil ramifications might fall. Now, let's say that the ticket is not supposed to be transferable and the garden feels that it's losing revenues or whatever, Ticketron or Bass Outlet or whatever, feels that it's losing revenues by scalpers selling the tickets above or whatever and taking away their commission or whatever it is by doing it unlawfully on the street and wants to, nail these scalpers, and so they're suing them for damages. That's the conundrum I was trying to present. Okay. Now, what becomes even more difficult, I should think, is if the client has been charged with loitering, but he or she was in fact a prostitute, they see the person in front of them plead guilty on a charge of loitering to an offense under the Ontario Ticket Speculation Act and join on the bandwagon and plead guilty to an offense under the Ontario Ticket Speculation Act. What do you do? I mean, you're at a real evidentiary disadvantage should Bass or Ticketron turn around and sue this person for damages who was in fact not scalping tickets at all, but was selling something else outside of Maple Leaf Gardens. I mean, it just presents a difficult conundrum. Of course, there are ways to use the fact that these minor of infractions, the convictions of which can be admitted in subsequent civil proceedings. For example, let's say that you own, or your neighbor owns, or somebody owns a prize water spaniel, and the neighbor has a swimming pool, and there is a bylaw which requires fences of certain specifications to be surrounding swimming pools, and somehow there's a hole under the fence, the dog slipped through and drowned in the swimming pool. Now let's say, even though your dog may in fact have dug the hole under the fence because he likes to be in the water, let's say that at some point a charge had been registered that there had been a bylaw infraction having to do with the maintenance of the fence around this swimming pool. If you are later representing the neighbor who lost the dog in the swimming pool, you can represent to the court the conviction, or the guy would no doubt pay a fine, $50 fine or something. He didn't fix his fence, big deal. He's not going to contest it that hotly. But he's going to turn around and be sued for the loss of the dog, and that conviction is going to weigh against him. That's an evidentiary procedure. So I think the only thing that really concerns me about this is that I think that it's not necessarily an expedient provision to eliminate this rule. I'm not saying it's wrong, I'm just saying it's probably not expedient, because you may well find that people being concerned about the civil liability and ramifications of the minor convictions are going to contest them quite strenuously at the lower court levels, and so that there's going to be a continuous backlog of things going through the courts. And that's about all I have to say on the subject.
Very relaxed. Well, on to another relaxed speaker. Don't we have Alan Gold before the coffee break? Should we have it now?
I think we should break for coffee.
If you agree, we should break for coffee? No.
Yeah.
You want to break for coffee? All right. Go.
People, we're a little behind in time, and the people.
The next speaker is Alan Gold, one of our more experienced criminal defense counsel here in Toronto, who will discuss Alibi. Alan graduated and entered practice in 1973 and has been in concentrated criminal law practice ever since, and I think many of you are familiar with his many writings and various criminal law publications. I'll ask Alan to speak now.
Thanks, Ken. First of all, I'd like to thank the drafters of this legislation. As I was entering my 10th year in practice, I'd pretty well run out of appeal arguments and felt I'd enter a rut. And I've been trying to estimate the amount of fees that this statute will generate over the next 5 years, and my computer broke down because it was just too large. It doesn't have the bad connotation of the charter, so I think that judges will sort of consider it in its own right, and it really is mind-boggling, the issues that will arise under this statute. So I thank Mr. Ewaschuk and his fellow workers for the additional work. Alibi comes from the Latin meaning elsewhere. It doesn't come from the Latin, as some prosecutors suggest, meaning perjury. The advantages to an accused of the alibi defense are obvious. The indignities inflicted on the victims during the bank robbery, the awkward statements to the police, no longer pose barriers to acquittal because it wasn't you who did them, it was somebody else. As a result, the alibi defense has a certain neatness and tidiness to it, not found in a simple, I didn't do it. Scotland had the first alibi statute in 1887. In 1920, some right-winger wrote an article in a leading American law journal describing alibi as the main avenue of escape of the guilty in the criminal process, a statement that has about as much validity as describing insanity as an everyday defense. But in any event, as a result of reading that article, the American legislators got worried, and beginning in 1927, American states began adopting notice of alibi statutes similar to this one. The advantage of all of this, of course, is that Canada is a Johnny-come-lately to an alibi statute. The advantage is there's a tremendous body of prior case law in the United States, all 50 jurisdictions, plus the federal, in Scotland, the United States, Australian Commonwealth. There's a gigantic body of case law, all of which, of course, will have to be researched at $200 an hour. I don't wish to read my paper to you. Those of you who have been called to the bar can read. Those of you who are students will presumably learn that before being called to the bar. I would like to focus, in the interest of time, and because Mr. Ewaschuk is next on the program, and I'm well aware of the risks of keeping him waiting, I'd like to focus on a few precise issues that seem to me will generate dozens of appeals in the next 5 years. First of all, what is an alibi defense? Some of you may have thought that was self-evident. I predict that it will take at least 5 cases to decide that issue, because here are the matters that arise. Section 80 says alibi evidence means evidence tending to establish, etc., etc., etc. What if the Crown's case, you're, for example, charged with bank robbery on day 10, and part of the Crown's case is that the tellers testify that the man who robbed the bank on day 10 was also in the bank on day 8. And the allegation, of course, is that he was casing the bank. I believe that's the terminology. And your client has evidence that he was elsewhere on day 8. Now, bear in mind that the offense is robbery on day 10. Does the evidence of being elsewhere on day 8 come within the alibi notice statute? I suggest to you that it does not. And if you look towards the bottom of page 7 of my brief written materials, then I put to you the general proposition that alibi evidence is a very precise matter. It focuses on the time and place of the commission of the offense. So you have to, for some criminal lawyers this may be a novelty, you actually have to read the charge and see precisely where and when the Crown is alleging your client committed the offense. If you're denying presence merely at some preparatory act or some part of the overall transaction that the Crown is trying to prove against you, then you don't have to worry about sections 80 to 85. In other words, you don't have to worry about your alibi notice, etc. Now, I should warn you that there is a 1973 case for which I really cannot generate enough criticism, but I'll give it to you anyway because the Crown may dredge it up. It's called Regina versus O'Neill, O-N-E-I-L-L, 1973. Of course, it's only reported in the Crown Reports. That's volume 22 of the Criminal Reports new series. At page 359. And in that case, the New Brunswick Court of Appeal said that if you're charged with possession on day 10, evidence of being elsewhere the day before is evidence of alibi. Now, with the greatest of respect, I submit that's nonsense. At the top of page 8, I give you the 2 British cases that support the proposition that merely being elsewhere for part of the story is not alibi. And in a case called Scambaluri, our Court of Appeal appeared to have says that very clearly. That was a continuing offense. It was a continuing series of events, but the charge was focused on a precise time and place. The accused led evidence that he was in Toronto for one of the earlier transactions, and the court said that that was not evidence of an alibi. Now, other examples of the same thing, subsequent events. The Crown's case, again, on a particular charge, particular time, particular place, the Crown's evidence may involve presence at some subsequent location. Again, contrary evidence that you were elsewhere is not evidence of alibi. Another situation that can arise is in a similar fact evidence case. If the Crown adduces similar fact evidence that is not itself the subject matter of one of the charges against you, alibi evidence with regard to one of the alleged similar acts similarly would not come within this notice of alibi statute. The other major issue that I suggest will arise with respect to alibi, the meaning of alibi, is set out in the next paragraph on page 8. Yes? Can I take questions? Just for the purposes of the record, as they say, the question was raised whether all of this was very interesting but a red herring, because Section 80 seems very precisely to say exactly what I've just indicated. The only reason I raise it is that the English legislation says exactly the same thing very precisely, and yet Mr. Lewis and Mr. Hassan were both met with contrary arguments by their prosecutors. So it seemed to me that if prosecutors in England, in the face of equally obvious legislation, were prepared to raise the issue, I wasn't going to give our prosecutors the benefit of the doubt, and I thought I had better deal with it as well. But I agree with you. I don't see how any reasonable person could think otherwise. But I never fail to be amazed that my view of what's reasonable doesn't seem to pass over to the prosecutor's office. Now, the other issue is this. What if the accused position is not, well, I was in Toronto during the Windsor bank robbery, but I wasn't at the bank robbery, period. In other words, he doesn't go one step further and give specific alternative physical location where he was. Now, here, I call sections 80 to 85 written by prosecutors for prosecutors, because here there seems to me to have been a very conscious sleight of hand on the part of the drafters of the legislation. In England, the definition in their statute is very precise. It says alibi evidence is evidence that he wasn't there at the time, etc., by reason of being at some other place at the time. In other words, the definition goes one step further than our Section 80. And that was left out of our Section 80. Now, I say with respect, that doesn't matter. That simply to deny being at the location is not an alibi. An alibi means elsewhere. It means to specify where you were. It's evidence that says that I could not, it was physically impossible for me to be guilty because I was at a physical location which is physically inconsistent with my being at the location of the crime. If you look in England, I'll give you an additional reference, a case called Gibbs, Gibbs. If you want to add this on page 8 under the Fritz case. Case called Gibbs, 1974, Criminal Law Review, page 474. And Gibbs says exactly what I just said as the law of England, and the commentary makes it quite plain. Negative evidence, simply that the defendant was not at the scene of the crime, is not alibi for the purpose of the comparable legislation. Now, I just raised that lest our prosecutors argue the difference in the wording between our statute and the English statute. And so I give you the Fritz case and one additional reference there's a multitude of American case law, but I'm just trying to pick the best one or two. Case called Commonwealth versus Mcqueen. And it's found in 112 Atlantic 2nd at page 820. And those two American cases dealing with comparable legislation to ours make the same point. And as the court said, okay, a defendant testifying that he could not say definitely where he was on the night in question without saying where he was not attempting to establish the defense of alibi. If a person says, I was not at the scene of the crime, but I do not remember where I was, he is not attempting to prove an alibi, even though he naturally had to be elsewhere if he was not at the scene of the crime. What is known in law as an alibi is an attempt by the defendant to prove that he could not have been at the scene of the crime because he was at some other definite place. So I would suggest the argument that based upon those authorities that in effect there is no material difference between our statute and the English statute. Another issue that I'd like to look at is the exclusion. There are two sanctions under sections 80 to 85. One is the judicial comment sanction, which probably doesn't change the present law that much. Let's look at the exclusion sanction. This statute says that if you trip over its hurdles, you can't adduce this evidence, subject to a judicial discretion. First issue that's going to arise is, does exclusion apply to the accused himself? In other words, does the Crown have the right, subject of course to judicial discretion, to say that because the accused didn't meet the statutory provisions, that he can't even, when he gets on the stand and testifies about what a wonderful person he is and his wife and his family and he has no criminal record, that he can't even say, I'm not guilty, I wasn't at the bank that day. And in my respectful submission, if you look at the top of page 9 of my materials, and again, undoubtedly the Supreme Court of Canada is going to have to settle this in the next couple of years. In England, there's the Jackson case, which suggests that even evidence from the accused himself is subject to exclusion. However, it's very weak authority. It's only one English judge. The Americans have had much greater experience with this issue, and although I concede there are two lines of authority, the more modern, up-to-date, and stronger line of authority says that it would be a violation of fundamental justice to disallow an accused to give such evidence because of such a statute. In other words, when the rules meet head-on, the accused's right to testify in his own defense prevails over any similar legislative provision. And so the most recent case is Alicia versus Gagnon, 1982 decision, which is cited in the materials at the top of page 9. I would also point out that if you look at that case and you look at footnote 7 of that case, that every single American commentator who has written in the area takes that view, and this strongly influenced the courts. In other words, no academic writer had ever mounted an intelligent argument why an accused's evidence should give way to such an alibi statute. Some people, the other case, if you want one or two good cases, the other case is the Merritt case from Michigan. It's the last authority cited in that paragraph. Merritt and Alicia and Gagnon are the two best cases. And the American Federal Rules of Evidence expressly provide to that effect as well. What about other witnesses? What about the exclusionary sanction even applied to other alibi witnesses? You may be interested to know, and this is an area where we're now closer to the states because of our charter, Never mind what the English and the Australians say. In the United States, the American Supreme Court has never upheld the validity of an exclusionary sanction, even applied to other defense witnesses other than the accused. The issue has expressly been left open on both of the two occasions that the American Supreme Court dealt with it. And those two cases are Williams and Wardius. U.S. versus Wolf I cite because that's a recent case that summarizes American judicial opinion concerning the validity of the exclusionary sanction even to non-accused witnesses. Undoubtedly, when you combine this statute with the Charter, then even my children are going to have a good practice for a long time to come. I mean, it really is mind-boggling, the issues that are going to arise. What about the validity of the sections generally? And I suppose this is the next question. And again, the answer is that if you look at the American case law, sections 80 to 85 should be struck down because there are two American Supreme Court decisions. The first is Williams versus Florida. This is the bottom half of page 8 of my materials. There, the American Supreme Court upheld notice of alibi statutes dealing with what's called a reciprocal statute. In other words, I'll show you yours if you show me mine. Show me yours. I'll show you mine if you show me yours. Or something like that. Wardius versus Oregon in 1973, they struck down an alibi statute because the statute did not require the prosecutor to make reciprocal disclosure of his witnesses. They said that it was fundamentally unjust. Of course, that's an awful lot like fundamental justice in our Section 7 of the Charter. The drafters of sections 80 to 85, I mean, they pulled out all the stops. They didn't even blush when they loaded the statute in favor of the Crown. If you trace through the prior drafts of the legislation, at one time they required the prosecution's reciprocal disclosure to go much farther than this, and that got dropped. And the statute that we have, I think it's fair to say, now would be struck down in the United States without a moment's hesitation because it effectively does not provide for any meaningful reciprocal disclosure by the prosecution of its response to the accused alibi. The prosecution, I suggest, should be required to disclose not only, what does the results of its investigation mean? I can hardly wait to see the first responses that come back from the prosecutor's office under that section. Surely not just the results of the investigation, a summary of the evidence in response and the names and addresses of the witnesses the prosecution intends to call in reply to the alibi. In other words, what's fair for the accused should be fair for the prosecution. So that's a fundamental objection that can be raised to the legislation generally. Just a few other issues dealt with very briefly that I'll direct your attention to. What I call non-changes in the legislation. These are set out on pages 6 and 7. The order of witnesses business, those are the authorities on that issue. Matters that the judge changes that haven't been made are set out on pages 6 and 7. As far as the proper direction with regard to the burden of proof, I'll just give you one additional case that was just reported, and you could perhaps put this on page 7 above the heading Some Issues. It's R versus O'Leary, 1982, 1CCC, 3rd edition at page 182. And that's the New Brunswick Court of Appeal. And the court affirms the principle that it's not just enough to give a general direction on reasonable doubt. When the defense's alibi, the jury should also be specifically instructed that a reasonable doubt about the alibi results in an acquittal. And those are, in the interest of time, all the comments that I have. I have to repeat the question after you ask it.
I get the impression from what you're saying about sections 80 to 85 that if I make statements to the police, I'm in worse shape if I say exactly where I am than if I just say, no, I wasn't there. And I get the impression you're saying that that's not alibi by saying I wasn't there, but
Yes. Yes, the question is, if you say to the police that I wasn't there without indicating where you were, are you better off than if you say, I wasn't there, I was home in bed? And the answer is yes. Well, subject to this, though, at trial, if you go a bit further and say, I wasn't there, I was home in bed, then if the statute is valid, you come within it. So the question is, what is the evidence at trial? That's what this issue is all about. What is your position going to be at trial? The point is that if at trial you say, I wasn't there, period, the prosecution can't use this weapon against you. If you say, I wasn't there, I was home in bed, then assuming this legislation is valid, you're subject to all of its implications.
But that's a question that you need for the prosecution to answer. Where were you? It's assuming you're putting the accused in the box.
Well, you're asking what is the situation where the accused remembers where he was, but doesn't mention it. My whole point is that, is anything in life certain? I mean, is he really sure that he was home in bed, as opposed to, all he knows is that he just wasn't at that bank that day. I mean, who keeps a diary? Who can account for all? And a very important factor is how long after was he asked by the police? If he's asked 2 hours, that's one thing. If he's asked a week, a month, a year after the event, I think it would be ludicrous to expect him to remember where he was on some specific occasion.